class. Today, let's talk about English system. What about English law? Uh, the main place of creation any concept of English law is, as you know, is UK, United Kingdom, which consists of two main lands, England, Wales, North Ireland, and Scotland. So, taking everything in summary, concluding all points, is that in English law, legal person treated with distrust and called it legal fiction. So, in understanding legal person and corporation in English law, they adopted principle legal fiction. What about legal fiction is? Let's talk about Savigny. As you can see, the fourth item in this PPT. First of all, corporation exists only in the law. In English law, they uh, didn't want to accept that we have legal person as a separate person, new person. We have individuals and we have something new one. So they didn't accept it. They took a position that it's all artificial creation to avoid liability by shareholders. And they adopted the concept of the major German scholar Savigny. You can see him, Friedrich Karl von Savigny. He created the theory that legal person cannot be without his personal without his person's will. Savigny actually didn't create legal fiction theory, but he created the theory, established the theory, which says that legal person cannot survive and live without members' will. So even if we create something new cannot survive itself. That Savigny uh, was Savigny's statement. For example, in case an individual, we have own brain, right? So we have own mind, so we can think, we can change our mind, we can act basing out on our own mind. But in case of legal person, Savigny said that legal person cannot work, cannot think anything without his members' mind will. So his statement was like legal person is the same with individual, but written on law. Basing on Savigny theory, legal fiction theory was evaluated and created. In case of legal fiction, is the three main points. Corporation exists only in the law, so that's why legal fiction is like only fiction by the law. It's artificial and it created just to avoid liability. Last time, if you remember, I told that English law created the concept of incorporation, created concept incorporation. What was the main point of this? Legal entity, its status obtained by government decision, originating from maritime law. Corporation conducts private and public matters. What it means? I think, I have somewhere. No. Okay, I will explain it. I should have somewhere. Oh, okay. I have explanation here. When I will talk about joint stock company, I will explain it. Okay. Just remember that English law created the concept of incorporation that uh, legal person can take permission to conduct business after obtaining government permission decision. The origin is maritime law, I mean the sea law of the sea, because of a lot of ships opened new regions and started trading with the European continent and Asian, American, African continent. The government gave a permission to such ships and the group of persons to run the business. So such corporations had two functions. First is private matters, and the second is public matters. What it means? They did business, I mean, they traded, but the other point was public matters. So they conducted also public interest in that areas as well. That's why um, we should say that English law gave to corporate law the concept of incorporation that we use nowadays. I hope it's everything clear. Everything fine? Any questions about this matter? You can chat me anyway. Okay, I will move to my back to my previous PPT. Let's talk about what corporate law regulating. I don't know about Vietnam. Do you have business law and corporate law? Do you have both subjects? I have first question. Do you have business law and corporate law?
We have something similar called enterprise law.
Yeah, same. We had enterprise law before. Have you ever thought about difference between business law, enterprise law, and corporate law? You know the in Western countries they don't use definition business I mean enterprise law. Even the word enterprise is not used so much. I read a lot of I read books in corporate law. I mean Western UK and US and German books, and they don't use the term enterprise. However, enterprise is a is one kind of corporation. As you remember, last time we talked that enterprise is like property owned by single person to run business under the specific company name. So actually, enterprise definition enterprise is used basically in communistic and Soviet law systems. However, Germany system created such term. Um, they use business law in matter not corporate regulation, I mean in wide view. In business law, they say it's license, incorporation, liquidation, some tax issues, customs issues, and including corporate law. So business law is kind of big area which include all matters related to business. Corporate law is a little bit small area, small area, which includes only legal person related matters. For example, individuals cannot be included in corporate law because they are not corporation. Um, even enterprises with single ownership somehow cannot be included in corporate law. Actually, if we talk in pure, if we talk about pure corporate law, we should say the single owned enterprises cannot be included. Sometimes, I mean, some scholars says that even partnership cannot be included because they don't answer to the main features of corporation. Anyway, um, I I I'm kind of taking positions that corporate law is a little bit wider and should include all union of persons and capital. So if we have one or two union of men, I mean persons and capital, we should say it corporate law. Of course, we shouldn't say individuals. It's different. Individuals cannot be subject of corporate law itself. Anyway, why we should use term corporate law, not company law? It's just problem of definition. I mean words problem. Corporate law is a separate subject, what we study. Um, a well Head Start, was adopted as a subject in US. US used the term corporation. That's why we call corporate law. That's all. There's actually no difference if you say company law or corporate law. We can say the comparative company law. We can say comparative corporate law, company law. There's no actually any differences between them. The clear point is that corporate law, what we study, is a different, separate sphere in private law. If we talk about Roman system, I mean Roman German system, we have private law and public law. In private law, we have separate sphere area we call corporate law. The C point, the last point is what's the aim of corporate law? Actually, I have special PPT about it. A lot of discussions. What's the aim, target of corporate law? What should corporate law regulate? Someone says that corporate law actually aim to make a lot of profit to shareholders and protect shareholders. Some scholars and systems say that we should protect creditors, government, society. And the third scholars and different option say that we should harmonize the system and protect creditors at the same time. So we should keep the balance of interest between all participants in such a relation. So it's a big issue. Actually, basing on adopting which concept you take, your corporate law will change. So if you adopt first one, your corporate law will be more profitable for shareholders. If you adopt more position for creditors' interest, it will affect your business atmosphere because a lot of investors will not be interested in your government, I mean, in your system. They will be reluctant to run business in your state. So the next one is object of corporate law, as you can see. Actually, it's regulating three major relations. First is internal, second one is external relations, third one, second one external, third one is a relation between parent companies and subsidiaries. But scholars say we have fourth object. Liability of corporation is directors and members for corporate debts before creditors. So it means that first, what is external relations? It's between actually all matters inside of company. I mean, shareholders and shareholder and the managing board. External is a corporate and relation between corporation and creditors. For example, laborers, counterparty, etc. Government, tax office, license body. I mean, only in sphere of corporate law, not all matters. Only relating to corporate law matters. The third one is between relation between parent companies and subsidiaries. And the new relation is liability of corporation. It's kind of new area. What it means actually, you know, there we have two big, two big. I better to show it how it actually look like. It's interesting. I don't know whether you studied in your country. It's really interesting the concept in English and German law. I want to say so. Have okay. I will make it smaller. Okay, you can see right this one. What's the difference between two systems? We have English system, and we have actually German system. Okay, you can see right. Um, the two figures you can see, it's showing difficulty of running business. I mean corporate form. So difficulty in corporation is much less than running. So if you run business in UK, it's much harder than incorporation. You can easily incorporate company, but in case of running, you have a lot of obligations and responsibilities which you cannot avoid. For example, outstanding example of difficulties in English system is if your actions did lead to bankruptcy of your company, you will be punished by civil court. Your title of director will be taken, abolished, for example, for 5 years. I think in your country, such title can be taken off in case of criminal court, right? If your director did criminal case. Am I right? In UK, it doesn't matter criminal action or not. Civil court can decide, okay, your action lead to bankruptcy. You cannot be director, take a position of director, and run authority of director, for example, for 3 years. What about your country? Do you have such system? I think you have, but the matter is, in your country, civil civil court cannot decide such matter. Only criminal court can decide. Am I right?
Uh, we haven't learned about criminal law yet that deeply, so we don't know if a criminal record could abolish someone's title.
Mm, I see. Okay, you can ask your teachers about it. It's interesting. After, uh, I think you have German model. Anyway, because we have the same background. I mean, my country, your country, and Germany. I think you have German model. What's saying in German system? Incorporation is harder, more complicated than English system. What it means? High requirement to charter capital, uh, procedures to members, registration. You cannot create company like in one day in Germany. It takes for around 1 month. In Switzerland, in Germany, it taking around at least 2 weeks to open, create LLC, limited liability company, because incorporation rules is difficult. In UK, you can open company like in 30 minutes. If you pay extra, you will have company opened immediately. So UK making money from incorporation. Germany is a little bit, they're doing filter. I mean, they're filtering the businessman. It's kind of permission to specific persons to run business. But running rules, it's much easier than English system. I mean, liquidation, creditors protection, and judicial system is much easier in German system. So in all corporate law, we have two big like models, English or German. Which you should apply, it depends on you and your country, I mean. Some countries, like I think your country also, we're using mix. What big mistakes of our countries? I saw it many times. Even Russia, Kazakhstan doing the same problem. I think your country is doing the same. We have a kind of new model. What can how can I call it? I cannot say any label. I cannot stick any label. Okay, new model. Let's say new model. It doesn't matter. What they do? They doing this? Is they doing this? What? I hope you understood what I said. What I'm trying to say. I think you have in your country you have this new model, right? In your country, I think you can open company in one day. Is correct?
We will make a registration, business registration, and waiting for 3 days.
3 days. Okay. So you okay? I will do like this. Okay, little bit different. Which model is correct? It depends on country, culture, and business culture, and the law. But it's not good one actually. We should have a balance of interest. We should filter at the beginning, or we should set difficult rules in running of business. I think you should always use or English system or German system. They are both good. English system good to prompt business activity. I mean, to run business immediately, it's better to use English system. But if you're in your country, I mean in your country, your business running ideology and manners are not good, not outstanding, it's better to apply German system. I mean, this one. Because it doesn't matter which corporate form you use. The most important, how your people apply it. I hope you understood my points. We will talk about more. So different concept making different rules for incorporation, management board, share transferability, liquidation, etc. What we're gonna study in this class. Okay, I will go to my next PPT. Is a continue of my previous PPT. I talk about it, right? So main features summary. Okay. What is corporate law actually is, right? we talk a lot about limited liability, but actually limited liability was not main point of corporation in English law. Limited liability created by German scholars. We should point that limited liability created by German scholars. Incorporation, like a separate institution, created by English law. You can see the first point is limited liability didn't become a standard feature of English law of joint stock companies until the mid of 19th century. In the American state of California, shareholders bore unlimited personal liability for corporation obligations until 1931. What it means actually is because of legal fiction theory, because of denial by English law, they didn't accept limited liability. But German legal system adopted limited liability to joint stock companies in 19th century when they created joint stock companies. But English law at that time didn't apply such rule. It's the first is the most important point. What you should remember is that limited liability wasn't main feature in English law. And after that, English law adopted limited liability because it's most, I would say it's because such concept satisfying shareholders' interest. The second point in this PPT, entity shielding, I mean corporate shielding, protect assets of the firm from the creditors of the firm's owners, while limited liability protects assets of the firm's owners from the claims of the firm's creditors. What it means, I hope you understood the point. This one. What's happening? When we establish corporation, the property is no longer belong to owner. You should remember, when you give property to company, such property doesn't belong to the individual anymore. It belongs to the corporation. So creditors of individual cannot take a property you just gave to the company. It's the most important point of this corporate shielding theory. Limited liability concept protect my private pocket, I mean my pocket, from corporation creditors. I hope you got it right. So I investing money to corporation, and creditors of company cannot take money from my pocket. They only take money from company pocket, not my private pocket. The main concept is this. Do you have any question about two main points, what I just talked? I hope you understood.
Can you explain the first part again? Entity shielding.
Entity shielding, it means, okay. Entity shielding, I mean corporate shielding, corporate protection theory means that I'm handing over a property to company, right? I'm individual establishing company. I should invest some money, right? Property or money to company, right? I mean to my portion in charter capital. If I'm giving property to corporate company, it means that such property doesn't belong to me anymore. Is it clear? So property, for example, I have phone, right? I have phone, for example, it's my lovely phone, Samsung. I like Samsung. For example, I'm giving my phone to company. So it means this asset is not mine anymore. It belongs to company. By the way, you should enter again after 1 minute because it will be switched off my Zoom meeting. What it means? Let's continue. Property from my pocket going to company pocket, right? That means that phone doesn't belong to me anymore. So my creditors cannot take phone from me because it's already belong to company, right? Is correct? That means that corporate shielding, protecting property from my creditors.